The next.
Familiar with that one.
Yeah.
Cool, I'm talking to you.
Aren't gonna be in our case anymore. Yeah, we don't want your talent there, but.
Well, when I
See you.
when I.
As you saw. Jail or no jail? A lot of parents want to file
Yeah, that's what I just said.
time and then like in a
This is a good guy. That's the way they do it.
time.
I'm back here, I'm Tom. You can hear? Okay.
What was yours?
I will.
Great.
Let's get started. Harvey will take his seat immediately. Dean Audier will be here at some point to welcome us, but in the meantime, I will welcome all of us. And a couple of announcements. Judge Newell is going to turn over the duties of liaison for criminal appeals to a designee to be named later. I feel like I'm at the trading deadline in baseball. In the meantime, Sion Shiap, who is the general counsel, will be filling in for him with us. We have a new date for our next meeting. It is going to be a 2-day meeting, and it's going to be September 30 and October 1, as opposed to a week later. I hope that doesn't inconvenience too many people. It's all my fault. I screwed up something scheduling wise. Which there was. So blame me if there's a problem. Andy Jones is taking over for Cynthia Simmons. And Andy is here, but he's got a hearing, so he says. But he's seated right over there. He'll be the liaison on the State Bar Rules Committee. And we have a reporter, Kim Cherry, who is filling in for Dee Dee today, who is, I think, got a court assignment to avoid. And I think those are all the announcements, unless the dean has appeared. He is here. So, Dean, the floor is now yours.
Good morning, friends. I apologize that I'm not there in person. But welcome to the law school. If I were not traveling, I would, of course, be with you. It's such a pleasure for us here at the law school to have all of you here for this important gathering. We are, obviously in the academic business, and we're incredibly pleased with the impact and the successes we're having in terms of bringing in world-class students and educating them and sending them out into the world. We're excited about the scholarly mission, and the caliber of our faculty and the impact that they're having. But as important as any of that is what I think of as the convening function that has been a priority for the law school, really from the outset, but I've focused on it particularly since I became dean about 4 years ago. This notion of the law school as a place where we come together to discuss some of the most pressing challenges and issues of the day. And so this gathering really is reflective of that. Obviously, the work of the Supreme Court here in Texas, the work of the courts in general, are among the most vital elements of preserving and maintaining and building upon the rule of law. And so this gathering being here at the law school really is a great honor and pleasure for us. I invite all of you back for future occasions as well. But for the moment, just wanted to thank you for being here and to welcome you to the law school. Thank you.
Dean, thank you very much. And can you either confirm or dispel a rumor that the students here call you Dean Bobby? And if so, how did that happen?
So yeah, the Dean Bobby is actually progress. No, Dean Bobby has become the norm. Although now that's complicated, as many of you know. Sort of now we have 2 Dean Bobbies in Texas legal education. So we'll have to decide. Bobby Chesney and I at the University of Texas have been debating. Is one of us? I suggested I be Bobby the elder and he be Bobby the younger. He likes 2.0. So we're deciding that issue. But this is an improvement on previously the students before I became dean just called me Audier. So I figured Dean Bobby is progress.
Great. Well, thank you so much. And thank you so much for allowing us to use this terrific facility. It's great space, and your staff has been beyond belief. They've been very helpful to us. So thank you. Thanks very much. All right. Now, without further ado, we will turn the floor over to Chief Justice Heck for his usual report.
Just a couple of things. The court usually takes a break during the summer, and we did this year. And so things been a little quieter at our court. We're expecting to issue another emergency order before this one expires September 1st. And over the course of time, we've been moving back toward standard procedure in the courts, and this order will probably move further in that direction while still allowing remote proceedings. So, of course, we're hoping for a rule soon from the committee that will place the emergency altogether. We also have an emergency order on evictions. Texas has, by most accounts, the best eviction version program in the country, and expect to get some more federal funding after September the 1st. So we'll keep that order in place, trying to support eviction diversion proceedings. The courts are working very hard on their backlogs. Announced last time, the courts of appeals are pretty much caught up. I think there's only currently one exception to that, and everybody's closing in on it. The rest of the courts are very hard. Courts of appeals have worked very hard to become completely current on their dockets. The trial courts are having a little more difficulty. So some counties are caught up. Collin County, El Paso.
Do we know anybody from there?
Yeah, we have a representative from there. El Paso is caught up. A lot of Panhandle and Northwest Texas caught up. A lot of East Texas is caught up. The big delays are in Houston, Dallas, San Antonio's digging out pretty well, and Fort Worth. You've read about some of that in the press. But they have extra funds for visiting judges, and several have developed special programs trying to identify cases that they can get cleared up. So everybody's hard at work on that. It's going to take Houston in particular to back on. They have a very heavy one, and part of it's left over from Hurricane Harvey because we're without a courthouse. And I should mention that in all these areas, the backlog is really in the felony. Civil courts are within 3 or 4% of being caught up. Juvenile courts are caught up. So it's the misdemeanor courts are making a lot of progress. The felony court work to do on. Then this committee approved an expanded disclosure of counsel rule in the appellate rules, requiring counsel to not just who the counsel are in that particular matter, but who have been counsel in the past. So we're already getting fuller disclosures that will happen. For example, that as we discussed, that lawyer will appear counsel at some early stage or other stage of proceeding. Then some years later, after the case is on appeal and maybe to our court, that lawyer will have dropped out. It could be a disqualifying consideration for appellate judge. So that broader disclosure is in place, and we're already getting, as I say, longer list of people who have stated in the proceedings in the case. And then the only other thing I'll mention is that we also have a new local rules process. So starting January the 1st, the longer undertake to approve local rules to be effective. Local rules, standing orders, and the like have to be posted on OCA's website. And once they are, there will be a review process. Anyone sees a local rule, they don't think should be the local rule. Challenging that and considering regional presiding judges will oversee that process. Recommendation. So that'll be a change. Hope it'll kind of reduce the burden on our court and provide a more thorough process who want to promulgate and review. That's all I've got.
Great, thank you, Your Honor. Justice Bland.
Just add that no rest for the weary in August for those of you who are on subcommittees that were making presentations today. So we're very grateful for the work that you've put in over the last several weeks. If you have an agenda item today, so thank you.
Yeah.
And I meant to introduce Mr. Starnes, who's here today with the court staff, our public. You may remember Osler McCarthy, who served for many years in that. If you think taking a step forward, we have.
Be sure to tell us.
Yeah, Osler's a great friend. But we welcome Amy to the court. Mark with my staff, Jackie, rules attorney.
Terrific. Well, speaking of hard work on short notice, the committee that is chaired by Jim Perdue got a great important project on 2 weeks' notice and sprung into action and have produced a terrific report. I'll add my thanks, Jim, and turn the forum over to you. Lead us through it.
Thank you, Chip. So let me begin by thanking Sheila, who has always been a great support as far as the logistics. I don't know if she's here, but Kirsten Evans is the director of the physical plant of the building, and I've been in contact. But thanks to her also for coordinating. Obviously, after my fantastic experience with the debtor and creditors bar, this assignment, fortunately, I'm blessed with a subcommittee membership that is incredibly knowledgeable, dedicated, fair-minded. I will, half of Pete Schinken, who is apparently traveling back from the Arctic Circle to Norway, he sends his regards and what be here, active in the.
By the way, Jim, he also sent a memo to us yesterday that we distributed to everybody and posted on the. We posted it.
There's a 2-page memo. It's statistics driven regarding the numbers of these. I've got a hard copy, but want to see it. So the issue that got handed to the legislative mandate subcommittee was this. With the Supreme Court's decision in Dobbs and with the Texas trigger bill, House Bill 1280, would we reanalyze the rules that the court has promulgated to give essentially procedural effect to Family Code Chapter 33. And so I was thinking about this conversation today with all of you who have been colleagues of mine for over a decade, most of you, and I was thinking about something that Chip said, I think at the last meeting at the close of the last term, which is one of the privileges of serving on this committee, is to serve with people on both sides of the bar, from across the state that can disagree and disagree mightily about propositions in a fair and reasonable fashion, in a model, so to speak, for civil discourse. And that has been the great tradition of this committee, and it's been always important. And I say that really for the public's consumption to understand that while people in here can disagree over principles, everyone in here has always held to the principle that Chip described, which is that civil disagreement and discourse is always social and civil and with respect. This is a particular issue when it comes to the policy proposition is one of which I think people on both sides with reasonable disagreements can disagree on passionately. But today is a proposition not on the policy proposition, but we're on the procedural proposition under Texas law and the effect of rules that are designed to give effect to a legislative mandate, thus my subcommittee. Family Code Chapter 33 is still the law. And while there is a health and safety code amendment that will be in effect as of next week after the Dobbs decision, squaring the two remains a procedural proposition in the estimation of the subcommittee. So there are examples relevant to this, but I will start with this basic syllogism. The Texas trigger law says that abortion remains legal in the limited circumstance where the health, life, and significant health risk of the mother is identified. There are definitions and terms around that. The syllogism obviously is that that woman, as defined in the Health and Safety Code, with a potential exception to allow for illegal abortion, may be under the age of 18. That is implicitly undeniable. And if that is so, then Chapter 33 of the Family Code, which is still on the books and remains a mandate to the Supreme Court, and remains a possibility that a woman under the age of 18 may be found to be pregnant and be suffering from a medical condition of the pregnancy, which is an impending threat to the life or safety of that mother. So in that context, the procedural proposition is this: are there ways to perhaps address Chapter 33 in a situation of a woman under the age of 18 that has a procedural avenue under Texas law to achieve a alternative form of consent, not an alternative determination of the propriety or impropriety of the abortion? Has never been that. Is an alternative to a form of consent for a minor. And that's what Chapter 33 represents. And those parental notification rules and judicial bypass rules then are laid out beginning at page 2 of the memo. There has been outstanding work in the past on this, of which we don't need historians, we have witnesses. Lisa Hobbs was part of the group that was instrumental in developing these rules in 2015. Alex Albright was part of that group as well, and she reached out for some of that history. But I do not need to play historian because there were people there who were part of that work and witnessed. So the memo, as you will see, identifies what then in Chapter 33, 003 specifically, provides for a legislative determination. The rules that are in question are only an effort by the court to provide procedural guidance to effectuate a legislative mandate. That legislative mandate in Family Code 33 remains on the books. So therefore, those rules were adopted by the court, and there is a link to those rules. The packet provides you a substantial amount of materials, but essentially you have rules for the judicial bypass and then instructions and forms, which will lead me to the rubber meeting the road at the end of the presentation. In the context of medical emergencies, that is a definition set out in Chapter 171. That also predates the trigger law. And so that was on potentially the books even during the existence of Chapter 33 during the bypass. So it has never been the situation under Texas law that the judicial bypass provision would be eradicated by the medical emergency definition, because there's been a medical emergency definition in the law of the state of Texas during the efficacy of Chapter 33 in these. So the trigger law, which is House Bill 1280, which basically, I think most people understand, Dobbs predicates its applicability. As Dobbs came down in July, the result is that the trigger law would go into effect with the new codification of the language of an abortion ban with the medical emergency exception, Chapter 170A of the Health and Safety Code on August 25th. Those definitions then are found, they're cross-referenced to Chapter 245. You'll see those on the bottom of page 4. And then the breadth of the prohibition on page 5. And then with the exception as laid out by the subcommittee in 170A.002B. And I think it's worthwhile to note that the exception itself is one that it not implicitly, but rather quite explicitly puts it in the medical determination of a reasonable physician. So the definition itself begins with the concept of a licensed physician making the determination in reasonable medical judgment regarding the condition that would qualify for the very, very specific and very, very narrow proposition of a legal abortion under the exception. I will say, just because it's a collateral research that's come up in a case, obstetrical literature published back into the 1600s has consistently embraced the proposition that the life of the mother was to be preserved in the tragic circumstance of where in those times, most of them were failure to pass, maybe was stuck. There was some really graphic procedures, but the historical practice of obstetrics has always been one through history that the life of the mother would be preserved by the physician when the delivering of the child threatened her life. So the definition here then is one of reasonable medical judgment that rests in a physician with a very specific definition, again, crafted by the legislature of the state of Texas regarding that exemption and without comment regarding the policy, but again, rather back to the procedure. Let me start with this as well, Chip. I think everybody can understand that a condition that poses a threat to the life or safety of a pregnant mother needs to be not conflated, but rather distinguished from a more narrow, but often more broad terminology of an emergency medical condition. And so EMTALA, which there's a section addressing the concept of EMTALA, which is the Emergency Medical Treatment and Active Labor Act of federal law, deals very specifically with the concept of somebody who presents an emergency medical situation to an ER, either in active labor or an unstable condition, and the responsibility to have a screening mechanism in that ER and then a stabilization responsibility in the hospital. That's a very narrow proposition and one that needs to be calculated, I think, just again, to maybe take the plane up a little bit to the policy proposition. A life-threatening condition can be the 10-centimeter tumor in my colon that's found on colonoscopy next week, but that doesn't mean I go to surgery in the next 12 hours. It is identified as a life-threatening condition, but it is not an emergency that would be the equivalent of a placental abruption with active hemorrhage, where a mother is losing some serious amounts of volume of her blood volume. Those are two different propositions, and therefore the definition as chosen by the legislature contemplates not a medical emergency of acuity, but rather a situation that identifies a threat to the life and safety of the mother, which may be urgent. But there is a distinction in medicine and in the law between urgency and medical emergency, which is the acute delivery of care with or without consent, whether it be EMTALA or even under the state health and safety code. Those are two different propositions, and therefore the law as defined by the legislature, and then the procedural effort to give voice to both the law in Chapter 33 of the Family Code, but in conformance to this narrow exception, needs to recognize you don't need to be bleeding out actively to potentially have a situation where a woman under the age of 18 is pregnant and suffering a life-threatening condition. But I think it's relevant to give you the EMTALA language, understand those definitions because of the potential interaction here, but it's important to distinguish, I think, some of those definitions when you get down to the responsibility and the recommendation of the subcommittee when it comes to the procedural proposition of rules. Procedural proposition of the rules remains to give will to Chapter 33 of the Family Code. And there is nothing about giving will to the Family Code as the subcommittee has read it, which would eradicate that statute or the procedural voice to that statute as crafted in 2015, even after the trigger law. So there are two basic recommendations of the subcommittee given that history and given that statement of the law. Recognize that the rules kind of loyally track Chapter 33. And so that the rules that were crafted by the court, again, in obedience to the legislative will rather than whole cloth, try not to do disservice to the procedural mandate and it's essentially incorporate much of the language of Chapter 3303 into the rules themselves so that there was no essentially distance between the rules written by the court and the legislative mandate that exists in Chapter 33. Given the way the definition is laid out in the new Chapter 170A of the Health and Safety Code and trying to then make continued loyalty to Chapter 33 and the bypass procedure, but to recognize that the situation of an abortion globally is one of a very narrow exception, but then also to maintain loyalty to both the language of Chapter 33 and the language of Chapter 170A, which makes the determination of this proposition for an exception one of a medical proposition rather than one of a judicial determination, and recognizing that the rules in Chapter 33 have always removed judicial determination from one of a policy proposition or a merits proposition to one solely of a procedural proposition on whether the two exceptions within Chapter 33 have been met, which is the maturity of the child or the circumstances that are a threat to the child justify potentially the bypass. That will can still be done with this recommendation. The recommendation begins at the bottom of page 8, which is a new paragraph to the general provisions in Rule 1.1 applicability, to recognize that the rule is not intended to be inconsistent with current state of the law with the prohibition on abortion unless there is a life-threatening condition, nor is there to be a judicial determination considered to be deemed of that proposition through the judicial process of the bypass. It is only one that remains loyal to the language of the statute in Chapter 33, and whether the two exceptions as laid out in the procedures that are laid out in the rules that essentially try to incorporate those procedures have been met. And then in addition to that proposed change from your subcommittee, there is an additional paragraph to the forms that are the instructions given to an applicant. Now, obviously, these are given to an applicant of a variety levels of sophistication, but they are also given to a variety of pro bono organizations and assistant organizations on both sides, by the way, that address that. And therefore, the subcommittee thought a statement of the law post Dobbs and post House Bill 1280 into those rules so that the court can clarify procedurally that it is the policy of the state. And so this essentially represents a statement of policy in the procedural aspects that an abortion is only available under the very, very narrow definition and the narrow exception that has been written into 170A. And that was our effort to try to not do violence to Chapter 33 of the Family Code, honor the court's past work regarding having rules that are obedient to that procedural process set, and to square that kind of under the law with the revised Chapter 170A in the Health and Safety Code. And that was, I will say as the chair, I am a big believer of something that's verbalized often in this committee, which is sometimes less is, and that a prescription that tries to do as much service with the least amount of engineering oftentimes is a more eloquent solution. So if I added anything to that conversation with the subcommittee, it might have been that. We're all very blessed to have the members of the subcommittee with the outstanding work. I can take zero credit for it was a effort by all, but ultimately I will say this: if there's any question about it, I'm here and available to take questions because I'm going to take full responsibility for this. My name's not on it, but you can consider my name.
Thanks very much. Well, your modesty is noted, but not accepted. So for the purposes of the record, I think you said that the rules came into force in 2015, but I think there was a prior version of the rules back in 2000 or 2001.
You're absolutely correct. The rules in 2015 were in response to amendments that were made in the session. These rules have much more history. And the chapter, in fact, has much more history. It was, I should be precise, that history was, it slightly changed in 2015, but it certainly predates that.
There are a few witnesses from 2000, but I'm still on this committee. Everybody on your subcommittee, with the exception of Pete, traveling from the Arctic, apparently is here, so they can speak their mind if they want. But is there any dissent in your committee to these two proposals?
I would rather not address votes of individual members. I think it's fair to say that there was not dissent, but I don't want to have this laid out on any individual.
Oh, sure, nobody does, but no alternative language that is lurking out there as there's sometimes used with our rules.
No, nothing like that.
Okay, and if anybody in the subcommittee wants to comment about this, now's the time to do it. You get preference. So if anybody wants to say anything, I think only one member is remotely and everybody else is here. So you want to say anything? Okay, we'll open it up to the floor. Let's talk about the first paragraph that starts with these rules continue to apply. Are there any comments on the language of this proposal? Peter Kelly. Justice Kelly, what's your thought about it?
There we go. my question is more general, not relating to specific language. But I'm just curious about whether there's an attempt to square the rules with the 1925 statute outlawing abortion, which is currently pending for the Texas Supreme Court and my court. So I can't really comment any further on that. I'm just curious whether y'all looked at that in formulating these rules.
Jim, there's an answer to that question.
There is. That was not in the scope of our project. We were very specifically referred to the issue of House Bill 1280, and that was our focus.
So the answer is no.
The answer is no.
There you go.
Your objection non-responsive is well taken, but yes.
All right. Anybody else? Let's have their hand. Good. Oh, yeah, Lisa.
This is very minor, but in the second to the last line, you refer to the female, which I think is probably tracking 178, but you might want to say minor there, which is more consistent with 33. But it's just in the rest of the rules, it to say refer to unemancipated minors. But that's very ticky tacky. I don't feel strongly about it. So
Former rules attorney.
exactly.
You have license to be ticky tacky. Any other comments? Yeah, Harvey.
Well, I thought that the second part of the sentence as an order doesn't mean this, doesn't mean that we've made a determination of the medical necessity to put it in shorthand version was really good, given what Tim has said about the way they tried to match the statute with the prior rules. I guess in my mind, when I read through this, I had a question, and that is whether that was in fact the way the statute needed to be interpreted. I don't have the conclusion in my own mind, but I had a question. So I looked at the two prongs, which are really going to whether notice should be not to the medical issue, as you said, and you're right about that. But I thought, well, if a young girl isn't mature enough to make the decision, which doesn't meet prong A, and so you're under prong B, which is best interest, who is making the decision for this person who's admittedly too immature to make the decision about whether the doctor's advice is advice that he wants to follow? I'm assuming that a lot of medical decisions are not bright lines, that there's some medical judgment to be exercised, and therefore reasonable people might disagree with a physician. And I just wondered who gets to make that call when you have a young girl who, by definition, if A isn't met, can't do that.
Is there a way this rule can answer that question?
Well, I kind of thought if A wasn't answered, yes, that she wasn't mature enough, then I thought the best interest would have to have some kind of inquiry into a review of an affidavit from the doctor or something. That was my immediate reaction, because I just couldn't think of who else could do that. Maybe an ad litem could do that. But it seemed like somebody had to do that, make that determination.
Judge Evans.
I don't dissent from the report of the committee. Practicalities of conducting this second prong is a real issue. And the value of the order to the minor, acceptance by the healthcare provider. The second circumstance that Judge Brown addresses is a concern of mine. I don't know how to address that with the court because I was persuaded by other members in that circumstance. There wouldn't be a judicial determination. Frankly, last night I went back, read part of Judge opinion in Cook's, the David Kinsley case. We see situations where parents and minors fight in open court over consent. I know the judges that do on bypass. And there is tragic of guidance on how to conduct the hearing. They're difficult. We'll hear from the applicant. They'll go through a, but at some point, the emotion of the moment will catch them. The circumstances they find themselves in that they never wanted to be in. And they'll tell you everything. Quite frankly, on maturity, you'll make the decision based on, as you do in all witness credibility, spontaneity, not the king. And it's a tough thing. I wish you would all forget that I'm a lifelong Republican, Aggie and male, and long ago an experience in charge of race relations in Berlin, and we would play a script where a black soldier one thing and a white soldier would say another, and we would show how a group would do this. So I'm trying to put this as near as possible. This second prong is a real problem. The ad litem is a guardian ad litem, not a guardian. They can't go over to the sin. It's the order of the court that the health rely upon. But I do know this. There are no mulligans in this deal. Don't get to swipe at the ball, send it down the fairway and say, oh, that was a bad order. Let's run back and find the judge, reporter, the private area, the whole dang thing. And let's get an order that the healthcare provider will accept. But spirited conversation. The brilliant people I work with, committee, but yes, I didn't dissent, but that is my concern.
What that little bird face wasn't comment.
It was, but that's okay.
Is there any way to tweak this language to address the very difficult situation in project cases that you're
I
talking
don't
about?
have hotel rooms for a week. I don't have but court has to where we are on this. Directions given to the judges of their duties. That I think this satisfies notification. But is that notification efficient, effective in situation number 2? I have an open question in my mind.
Yeah.
I understand the reluctance of those in the committee to have a judge make a determination. Medical. I understand that's driven by their perceptions of what the judge may do with that and their profiles of. And I understand that it's driven by the fact these are not open proceedings. The public doesn't have it. So there's nothing to do. First and hope for the best. But that woman is not going to get an order that can be used, as far as I know, in situation number 2. Unless the judge had some sort of clear, convincing evidence. Well, I don't know about the final. I don't want to launch in. Just going to get an order that says she's been here and I make the decision. She did it, and there's a healthcare provider of way passes, but that's my concern. And I don't think I'm going to see many judges that are going to off on them in situation number 2, unless they have some sort of proof from the doctor, the diagnosis.
Wouldn't the
Unless
doctor's
court just simply
testimony be,
instructs them, they can't
Sergeant.
consider it all.
wouldn't the doctor be, as it relates to make that determination, shouldn't the doctor be there to give her
I
testimony?
think the doctor's testimony is binding on the court. If it's presented properly, there's no question of it. I'd be a couple of judges practice. The great majority of us don't. And so that's where I may differ, and maybe we haven't ironed on that form. These are tough hearings.
Because of that, not to interrupt, because I'm certainly not a judge, but I think to prevent that type of activity, It's illegal for a judge to let, and so this is similar to being a medical professional, and that it's required that a judge have extended physician. Some physicians to make it.
Hearing is all the time, but I'm not sure I got everything. Just say that I've been groping with this for about 2 weeks now on this second prong, and my concern that part of that continues to be what's going to.
He has tennis in the morning, the tournament. Is that okay? You feel all right?
Yeah.
Okay.
So
Couple of comments. One, when you're speaking, if you could speak up, there are microphones in the ceiling. But who knows? But if you're especially soft-spoken, as Judge Evans can be on occasion, although not always. The people on Zoom are having trouble hearing, and the people on Zoom, be sure to keep your mics muted until you're ready. I think we just got some feedback a minute ago. This admonition does not apply to Orsinger, who would never be accused of speaking too softly. Beyond that, Justice Gray?
I think it's important for a court to recognize the point that Judge made, and for the committee to recognize whether, I don't know that you can fashion a solution for it, but that is an open question and maybe just speculation on my part. Me being soft voiced would, well, that's anyway.
I didn't accuse you of that all the time. Justice Gray.
I was going to try to make it a day without saying anything, and I didn't make it an hour. So here I am. But I thought from something that I read in the materials that this decision was entirely independent of the judge, of the medical provider's decision. And that in fact, it could be anticipatory to a medical diagnosis, that the bypass could be obtained, gone without any medical testimony. And in fact, the medical testimony would be irrelevant to the decision on the bypass. And then in effect, the minor would present the bypass, if granted, to the physician who makes the medical decision, at which time the procedure would occur. And so I just want to make sure, did I misunderstand the process of how it was intended to work, or at least an option of the way it would? Yeah.
Well, I don't think process ever designed to reflect an intent process. So there is nothing in the process currently or in this that would have anything to do with addressing quote unquote timing. Obviously, the rule, the application packet, we did add in the paragraph to reflect the legality and illegality, right, of the circumstance for the applicant. And that was the effort, but so I don't know where to answer neither yours nor the judge's questions on the pragmatics, because it's supposed to be a neutral proposition. You have a procedure that's available. It is not appropriate to get an abortion under Texas law now, less than this circumstance. Can the procedure be accessed before that circumstance arises? Nothing in the current procedure and the legislative mandate in Chapter 33 that states that. Again, not to, but what the judge is trying to address, I think, is what has been true under this Chapter 33 of the Family Code for 2 decades, which is the pragmatics of and this committee repeatedly kind of recognizes the concept of a qualified judiciary and litigants of good faith And in this process, by the way, Judge Brown, there is a mandatory appointment of a guardian ad litem.
I know that. There's
So-
questions the role.
That's right. That's right. What is the scope of that role? But there is a guardian ad litem that is mandatorily appointed in these procedures that does stand to the extent a guardian ad litem does in a different situation than just a minor prove up in a civil case. They do stand in a proposition of best interest of child,
Well-
not in guardian role, but they certainly are not just a counselor to the court in these particular cases.
My mind.
I have a further role. If you find the young woman is mature, the game is over. Medical condition makes no difference. If she's mature, I just want to point out that the way I read this, if she's not mature and sufficiently well informed to make the decision and have an abortion performed without notification or consent of a parent, managing custody or guardian, or number two, the notification and attempt to obtain consent would not be in the best interest. There are circumstances, one which made it in Florida. I don't know that I've judge reached that conclusion last week, that the young woman wasn't mature enough. But you could have that situation. And that's the only one I'm concerned. Because at that point, I believe it is the court that is giving the informed consent for the minor to have the abortion. It is not the guardian ad litem or anyone else.
Professor Albright and then Harvey.
Yeah, thanks. I'm sorry, I'm on the phone. I'm in Colorado, so thank you all for letting me talk this way. As I remember this procedure, the issue of best interest is not about whether it's in her best interest to have the abortion or not, but it's whether it's in her best interest not to include her parents in that decision. As I understand it, these are situations where there's been abuse by the parents. Perhaps one of the parents or step parent impregnated her. There are some situations where she doesn't have parents. One parent is dead, another is in jail and is not responding. So it's not about whether she should have the abortion. The judicial bypass is only about whether her parents need to be involved in that decision. So I respect the angst and the difficulty in that judges have in having these hearings, but I think the focus needs to be on the notification and or consent, and not upon whether she should have the abortion or not. And this is an issue that has always been there with these rules and these statutes. So it's nothing new after Dobbs at all. So I just think we need to remember what the focus of these procedures are. Thanks.
Thanks, Professor Albright. Harvey.
I was going to make the same point, but
Sure you were.
I really was. I was going to say that best interest, because I mean, this is something I read through carefully yesterday. And I thought, at first I thought best interest meant, you know, kind of the general definition, but it means best interest not to notify.
Right.
But we still have the question that even when we discuss this, we talk about, quote, the decision. Who's making the decision? If she's not mature enough to make the decision, someone has to make the decision. Is it going to be the ad litem? If so, then I think the ad litem's role in these, is it going to be we just hand it to the doctor and say the doctor's the one who decides without anybody questioning that medical judgment? Or is it going to be a judge? I don't see other options, but I may be missing one. It also occurred to me it's possible you could have an ad litem for the unborn child. The statute defines fetus, if you will, or the unborn child as a child. Therefore, it seems like that person may have an interest in the proceeding and is unrepresented. So I wondered if that person entitled to an ad litem too. I didn't have an answer. These are just questions I had when I was reading it through. By the way, great memo. Well done. But I thought that was a difficult question. what to do when it's under the second prong. I just thought it was worth talking about.
Whole of the ad litem extent, it's unclear. Wasn't that lack of clarity, doesn't that exist today prior to discussion?
It probably does, but before at least, there wasn't a legislative finding. This should only be done under this narrow circumstance. Now there's a legislative finding that this should only be done under a narrow circumstance. The question is, who's going to make that determination? So, I mean, I think this is the rule is perfect before the new statute. The question is laying two things over each other that aren't clear how to lay them over. I think it was a great job, admirable job, but I just raised that.
Lisa,
I'm not finding the statute because I'm not quick enough on my understanding what, Jim, you can correct me if I'm wrong, but my understanding was the subcommittee went to 170A and looked at the language of the statute, and it says that it commissions determination about whether the pregnant minor, or that's how I understood reading your memo. Is that correct?
That certainly seems to be the explicit language of the way the exception is defined. The fifth page of the memo. But you've got a three-prong, it's conjunctive, you have to have all three. And the proposition lives in the second, which is that it is the reasonable medical judgment, not reasonable legal judgment, the reasonable medical judgment of a reasonable physician that the existence of the would be the exception.
I mean, that's how I read it, and that's what gives me more comfort without discounting the angst, as we sympathetic are in. And what has been said today has been, I know, heartfelt. But I just went back to the plain language statute. And it seemed like the statute answers the question is that the physician who does decide, and that's the way I read it. I know it's not perfect, Judge. I know it's like not a perfect thing, but
It's a fair reading. But you're asking human to ignore the statute, asking human judge circumstances in it. The rule that tells the judge is to address the warning give to the minors. But we've never addressed how the judge is supposed to conduct the hearing. And you can find out these things will be 15 minutes pro forma, and they'll be 1 hour. And there's some unreported decisions. Said that where judge has gone too far. The issue timing. And I've had my soul bearing. I'll get my scotch tonight. But I don't think you've got an effective order. I'm the guy that has to replace the people that recuse themselves. This comes down. I've got to go out and balance. And I have to say, I can't tell you what you're supposed to do. I can tell you what some members, some people on each side of this question believe you're supposed to do, what the advocacy groups tell you to do. But I can't tell you how you're supposed to conduct that hearing, what evidence you're supposed to read, and what you're supposed to know. And I can't not point you to a reported case. That is going to, there is, again, no do-overs. Don't want to.
Judge Stebbins.
I think that the intent of statute was to allow doctor any pregnant female, the minor or not. So even though we need to apply it to bypass rule, as a child cardiologist had, bounds with back before. And I was pregnant. Was 6 or 7 months pregnant. And heart surgery. So, I was, because that was the only way for life. I'm gonna have to induce the pregnant into a where they but the way it reads, I mean, no one really has time to come to the judge as a minor. They're treating someone and they've got to make a choice. But this is to protect the doctors. You know, the baby's there. No one's coming. I read we all worry about that. All the people that have had a baby, we all worried about our blood pressure. Women or doctors would do whatever to lower. Understand those things. When that happens, that doctor doesn't have time with preeclampsia to go to get a court order from some sort of bypass. So even I understand we have to do this. The reality is there will be not one case under a legitimate life-threatening situation. I mean, to us for. I mean, it's just not going to happen. This is medical care. Like the doctor from a murder, from someone wanted that baby, wanted their spouse, whatever that might have been. So with that, if it did come up to the judge makes the decision. No question. We're making the decision.
Yeah.
We made the decision. Now we just hand them a piece of paper, and whether they go to the abortion clinic, that order allows them to go and have that performed, or they change their mind. They're the process, so even if I sort of can decide that immediately.
I guess both of you, both you and Judge Evans, is there anything that we could suggest as that the court could do to answer the situation Judge Evans anticipates he will find himself in? He's got to go to one of his colleagues and say, "You got to do this," and the colleague says, "Well, what do I do?" And I don't know.
I don't, first off, you call for dissent on I don't dissent.
Oh, I know.
I understand the reading of this is just notification, but I wanted to make sure, I thought it would probably come up with. The board is aware that this doesn't answer the question in the end. And I don't know how you educate is on how to. Sure wouldn't, that question hasn't been referred to the committee. And
if it is, we'll deal with it. But
if it is referred, it is, but this is not going to answer this isn't going to answer this is not going to.
If that question, go back to this.
No.
It is. It's just a nightmare of what it would be, but in the end of the day, it's most of these come in. Most of these things are filed within 10 days under the existing statute. Now, you can say that the bar that represents the women involved are trying to put the court up against the wall. Most of the urban areas have a local rule that designates a particular court. And so we know where the clerk knows where they go. But at that point, you have to scramble and have an ad litem. Usually there's a group of lawyers who work in this area, knowledgeable of what they're taking. Then you have to find a hearing in a location and then you have to have a hearing. And many of these young women have to schedule it in such a way that they avoid the people that they want to bypass. So it is, and it's not unusual, large area, when there's a lot being filed, and they're not a lot being filed. No. In an urban area, it's not unusual to find the judge out of pocket when it's fine. But then you have to go scout something. That's what happened to you today. You've got to sit with the judge. Well, what do? Read these rules. But now with the overlay and the reversal of Roe, and the events that are going on in the state, I don't think there's a single judge not going to question whether they're under the 1925 Act, whether they're supposed to consider that or not consider it, or whether they're supposed to consider HB good or should not. I wouldn't even want to speculate on what the legislature think we're supposed to be. Now, it may be just a big, maybe it's not a problem. Maybe we won't see it because frankly, I think most of these providers, we have lawsuits where parents won't give consent because of their beliefs. And the hospital and the minor has gotten outside legal help and they filed, the court then has to act in what Justice Birdwell would call over and over. Parent, etc. But you know, at that point, the court stepped in, solve them, but it's not getting us anywhere, but I'm listening.
Yep, thank you, Judge. Any other comments about this first paragraph? All right, let's go to the next suggested language, which is on page 9 of the memo. Abortion in Texas is only available. Paragraph we're talking about. Any comments on that language?
And that one looked good to me. Good job, Jim.
I can't take credit. Orsinger gets that one.
Okay, Rich.
Just one question is the verb states. I went back and looked at and it says determine, but it's to determine. I'm just wondering, where are they supposed to state? What are they supposed to do? I just wondered about that verb, if there was a reason that they chose states there rather than maybe determines, which I think is the statutory one.
That's an interesting point because I was thinking about the situation that was being posited by the district judges. I wondered if a lawyer representing a minor could prophylactically go and get a bypass order. His client is very sick, likely to need emergency care to abort the child. But it hadn't happened yet. The physician hadn't said so yet, but he wants to be sure that that piece is in place. I can see that occurring under these rules, in which case determines would frustrate that. Richard or
Chip, I would follow up on what you were saying. I mean, not all of these are emergencies. And the question is not whether there should be an abortion or whether an abortion would be legal. The question is whether the consent of the parents should be required. And if a underage mother is starting to develop difficulties with their pregnancy, I don't see why someone couldn't go into court before the emergency. And then it's not a question of whether you meet the criteria of statute. It's a question of whether the court is going to consent in lieu of the parents of medical. So the question of medical necessity or medical emergency is divorced. I question that. So I agree with you entirely that we should anticipate people may go into court before the emergency in order to have everything lined up so they can take the necessary steps when the emergency arises.
Justice Christopher.
Yes, sorry, I did want to talk about the first provision. Because in a way, it's a bit misleading, in my opinion, when you're looking at the minor's reasons for not wanting to notify and obtain consent from a parent. The minor often testifies that the parents are against abortion and, do not believe in it for religious reasons or whatever reasons. They do not believe in abortion. So a judge would have to ask the follow-up question. Well, have you ever talked to your parents about an abortion if there's a medical reason for it? So you will be getting into the medical reason for it. And, so to say at the beginning that we're not getting into the medical reason is not true. Because that'll happen. And when you put it up there at the top, it seems like it won't come up, but it will. If you're in the best interest prompt, because that's what happens in every single one of these cases. Because every case they come in and they try to establish maturity. And secondly, they try to establish the second prong just in case the judge doesn't think they're mature enough. So, I don't know if we're doing trial judges a service by saying we're not making this medical decision. And I just would like to know that you all to know that talking louder helps, but we're still having a really hard time hearing. Thank you.
Thanks, Judge. And were your comments, I think they were directed at the first paragraph that starts on page 8 and spills over to page 9?
Yes.
Okay, great. Are you having any trouble hearing me?
Yes, sometimes your voice just drops, even when you're talking loudly. It's just spotty. We think maybe it's a Wi-Fi problem.
Could be, and plus, sometimes I look down at what I'm reading and the microphones are above my head, so.
No, it's like just right then you cut out and you were looking straight ahead, so.
Okay, well, we have technicians over there working even as we speak.
Thanks.
Whoa, and your picture just popped up on the whole screen, so. You're looking good.
Thanks.
On the right.
All right, any other comments about either paragraph, but we're focusing now on the paragraph on page 9.
I could just respond to Judge.
I knew you.
Sorry, I can't help myself. But I think I agree with Judge Christopher that what's happening in like the full realm of things will come up in a hearing in a judicial determination of whether the minor needs to notify her parents before the procedure. And so I think Chief Gray said something about like it's irrelevant. I can't really imagine that it's irrelevant. Okay, it's going to come up. I agree with that. But I think how I read this provision as drafted by the subcommittee is there is a medical determination that will be made in Texas heretofore. And it is not a official determination about whether the abortion should happen or not. And I know it's not going to be easy and I know it's not going to be clean, but I think the words on the paper as stated here are very clear. Whose role it is to decide whether the abortion given in Texas is legal or not. And it's not the judge's decision. And that's how I read what was written and I thought well written.
Great. Anybody else have there? Any further comments? Yeah, Justice Gray.
I just can't believe that Lisa Hobbs would not agree with me on something.
Well, there's always time for a first, you know?
It's a real gnat, but right in the middle of the paragraph is an our pregnancy when it should be your pregnancy.
Yeah, thank you.
Catch. Thank you, Judge. Right? Any other comments? Anybody?
Is that a period after performed? On the second to the last line, or is that a comma? My eyes are hot now that I'm 40, I think.
Period.
It is a period.
They're gonna fix that in post-production.
Gotcha.
I think it's probably supposed to be a comma, but
Or nothing. Nothing.
Yeah.
yeah, or nothing. Yeah, sure. All right. Anything else? All right. Anybody violently opposed or even somewhat opposed to the language the subcommittees come up with? All right. Hearing nothing, then we will submit this to the court. Again, with thanks to Jim Subcommittee for the excellent work you've done. And we will turn our attention to the next agenda item, which is procedure related to mental health. Another easy topic for us. And Bill, I think you and Kenan are the team leaders. So far away.
Thank you, Chip. So at first glance, the topic that we're discussing may look expansive, difficult, and that's only because the general topic is expansive and difficult. But I think what has been referred specifically to this committee for consideration is actually pretty narrowly focused. So I'm going to provide a little bit of an introduction and overview, but I think it's important to focus on what we are being asked to address and what we are not being asked to. I think what we are being asked to address is a specific rule, potential addition to the Texas Rules of Judicial Administration. What we are not being asked to do is, in this committee setting, is to decide the public policy choices or the wisdom of specific pieces of proposed legislation pertaining to procedures at the intersection of the court system and mental health. I'll take a step back. The report that you have that's attached, first attachment to the memo, comes from the Judicial Commission on Mental Health, which was established in 2018 by joint order of the Texas Supreme Court and the Court of Criminal Appeals, co-chaired by Justice Bland and by Judge Hervey. And it's addressing a wide range of issues around the general goal of improving the administration of justice for persons with mental, intellectual, developmental disability. So the specific topics that you see referenced in this report are one slice of the much larger undertaking by the commission. The specific slice that is referenced in the report deals with one of the aspects of the intersection of the court system and persons, which is circumstances when there may be emergency detention because somebody is in a mental health crisis and may be at risk of harming themselves or others, and related issues, for example, the administration of psychotropic medications. So again, as a disclaimer, we are not being asked for plural to address the policy choices underlying proposed legislation dealing with these and other difficult issues. The commission would certainly encourage input from everybody who has interest in this. And the commission member, you've got commission representatives here and Justice Bland and myself. The commission regularly meets. So your input on those topics, if you have it, is certainly encouraged and welcome. But it's not really what we're here to discuss today. I understand the scope of the referral. And I would hasten to add, Justice Bland, if there's anything that I leave out or omit or that you'd like to elaborate on, please elaborate.
Well, you are more than a member on the commission. You're the vice chair.
So I would encourage everybody to who has input, please provide input on the policy matters. But let's turn to the specific rule proposal that's before you. So what you see in the Judicial Commission on Mental Health report, as Appendix B to that report, are a number of proposed plain language forms that the commission's has created with input from the various stakeholders to address certain of these circumstances and motions. What do you bring to the court? What is the person who may be subject to emergency detention? What are they going to be informed of? Those sorts of things. So there's really two pieces to the referral that we're addressing today. Number one is a proposed addition to Rule of Judicial Administration 10 that tells courts generally about these forms, how to address them. And then separately, the request was to review and suggest any particular changes to the proposed forms themselves with an eye towards plain language, straightforward, easy to understand. So I'm going to turn to the first part of this referral, which is a proposed addition to Rule of Judicial Administration 10. And in part, I think our discussion today is going to echo discussions we've had in some other contexts, for example, family law context, about persons who may be using forms and how courts should address those forms. So the basic gist of the proposed rule that the subcommittee is bringing to you today has two components to it. And there's some bracketed language. We'll unpack that in a minute. But the background of this is recounted in the memo and it's recounted in the Judicial Commission report. And there has been some robust discussion on the stakeholders of mission about the use of forms in this context. And I think everybody will stipulate that when we're talking about some of these circumstances, emergency detention, administration of medication, I mean, we're talking about serious personal liberty interests, public safety interests. You've got a lot of stakeholders involved here. You've got medical providers, you've got families, you've got persons who may be subject to these procedures, you've got law enforcement. That there are multiple significant interests bound up in that. And that recognition has led to discussion on the commission around the fact that there are 254 counties in Texas, some urban, many rural, and there is some recognition of the fact that no procedures can be one size fits all procedures. Forms cannot necessarily be one size fits all because the circumstances that may exist in urban area where there is more ready access to emergency mental health treatment may well be different from a rural area where the closest in-person emergency medical health treatment may be some hours away, or whether there may be some telehealth type procedures. So that's kind of the baseline for the discussion here about, are there going to be forms? And if so, what are we going to say about them? You see Judge Herman's comments or reflective of the probate judges he has visited with, who would often be the judges addressing these circumstances. So that's kind of the backdrop. One size is not going to fit all. Taking that as a given, what do we want to say about the form? The commission has proposed forms, and the recommendation came from the commission to put forms out there with the notion that availability of forms is preferable to just not having guidance at all. But if with that guidance, what do we want to say about them? So this proposed Rule 10, in addition to Rule 10 of the Rules of Judicial Administration, really has two concepts. Number one, use of approved forms is not required. And number two, court should attempt to rule on requested relief on the merits without regards to non-substantive defects in the filing. Those are the two core concepts in the proposed rule with bracketed points for discussion. So turning to the first bracket point, you'll see that a proposed preamble to this rule language is with respect to procedures under chapters 573 and 574 of the Texas Health and Safety Code. Those are the specific procedures that we're talking about in terms of emergency detention and related issues. Do you want to have that preamble in this proposed rule? The subcommittee's view on it, I'm not sure that there was a 100% consensus on it, which is why it's flagged and bracketed. It may be appropriate to use that bracketed limitation for this rule because that was the scope of the referral that we received. It was specific to this context based on the issues that the commission had addressed. But there's room for discussion about circumstances where are there circumstances where we want to say that absolute following of a particular form is required in an approved form. That's one big picture policy consideration. Another is this, relating to the second bracket. If a form is used, the court should attempt to rule on the requested relief without regard to non-substantive defects in the filing. Again, that narrowly cabins this based on the referral that we received, but it raises a larger question that goes beyond this specific mental health context. I'm hard pressed to think of the circumstances where we want to tell courts that they should avoid ruling on requested relief based upon non-substantive defects. I don't think of a circumstance where that would be something that we would want to encourage. So again, there may be a wider discussion to be had around that. And that may be something to discuss or start discussing today. Maybe it goes over into other meetings or broader referral or inquiry. Then the last bracketed language. This is sort of a carryover from the discussion that we've had periodically regarding pro se litigants, particularly in a family law circumstance. And in that circumstance where pro se litigants may be, bringing to a court forms that they've printed off the internet or something like that and asking for substantive relief in a family law setting. So that is included as an additional consideration for discussion about whether or not a proposed addition to 10 should have any reference to whether or not this is a pro se situation. You'll see from the forms themselves that I don't think the forms assume that there's going to be representation. There may be or not be, but the circumstances that are contemplated by these emergency situations are frequently the situation where someone has been diagnosed with a significant mental illness. They decompensate for whatever reason, and an emergency situation arises because the family members are trying to manage the circumstance, but they may feel that there's safety threats. Law enforcement is called or brought in, and it goes from there. So these are circumstances that are prone to happening without a lot of formal legal run. That's part of the reason why there's an emphasis on plain language, but it also highlights the fact that these may be circumstances where it's not neatly presented by somebody represented by an attorney. So that's kind of the overview of the first discussion. So I think with that, I would hand the ball back to Chip for how you hold the committee discussion.
Great. Well, Judge Peoples has got his hand up, so let's see if he's got any wisdom.
Thank you, Chip. I'm a member of this subcommittee, and I want to, compliment Bill Boyce for his great leadership. I want to express something that I spoke up and we talked about at the subcommittee meeting, but I didn't fight for this language that I'm going to suggest. The context here is the draft on page 4 that Bill has been talking about gives, in my opinion, too much deference to the local judges who don't want to use forms, who basically, and these are my words, they want to do things the way they've been doing it before, and they don't want to change. And I think that we're in danger of yielding to that interest of some local probate judges at the expense of user friendliness out in the field in 254 counties. And a lot of times we were dealing with rural situations where there are remote proceedings, and the user friendliness interest, I think, is more important than we are giving it here, because family members are going to be using these forms, and so will medical providers out in the field. And so on the very next page of the memo that Bill has been looking at, there are some bullet points at the very top. And the first bullet point on page 5 expresses the view that I, and I think other members of the subcommittee, expressed or at least had concerns about. I would like for there to be stronger language. I'm going to just read what Bill wrote here, requiring the use, not making it optional, but requiring the use of these forms unless the judge, the local probate judge who wants to do something else sends his or her form and the reasons for using something different to his or her presiding judge and gets it approved. In other words, letting people opt out when they have a reason that they can articulate other than, I've always done it this way. I'm comfortable with the way I have been doing it. And basically, the people out there in the field ought to conform to what I want, rather than me use the forms that the state has issued, unless I can come up with a reason that I can articulate as to why I want to do something different. And again, at stake, we need to be user-friendly to the people who are under pressure. And these are requests for emergency detention. Time is of the essence. And the interest in uniformity, which is mentioned in the memo from the JCMH, it seems to me has been given second rank status, and we need to take a look at that. So what I would advocate is at the top of page 5, the first bullet point, requiring the use of the forms unless the local judge wants to opt out and can articulate reasons and language and so forth, the details as to why he or she ought to be able to require the people in the field to do something else. One final point. No matter what we do, I don't think we can make judges rule a certain way. I just don't think it's possible, even if we wanted to take away the discretion to say, no, I'm not going to grant this request for emergency detention. That will always be there. But I think the fundamental issue that Bill has put on up for discussion is whether to require or not require these, and how easy it is for people to opt out. Thank you.
Robert had his hand up, and then Lisa.
So I see this process as being of significant importance. It involves the deprivation of liberty, situation where they're obviously going to be high emotions and focus trying to achieve what's in the best interest of the individual. But this is not like paying costs. And I think that clear, consistent process, and as Judge People suggests, it cannot be up to the deference of individual courts. That's why the charge is a consistent process. And the suggestion of the subcommittee that we should allow alternative forms leaves significant uncertainty and would potentially put an individual in a position where requirements of the law would not be followed in the same way in one county versus another county. And I think that we can solve the issue about local, rural versus urban in terms of the discussion. Makes a lot of, might be variance, but that variance should be examined in the context of the law require. This should not, I don't think this should be a situation where a local side, oh, they're her. This is.
Thank you, Lisa, and then her.
I appreciate that discussion, and I think I agree with you, although I'm still listening to what everybody has to say. But I wanted to add one thought on this, is that at the last Access to Justice Commission meeting, Justice Busby had mentioned the possibility that the Access to Justice Committee would look at a rule. I think he envisioned it in the rules of civil procedure, not necessarily in the rules of judicial administration, but I don't feel strongly on where you would place it. But what he, at least what I wrote down, he proposed, and so if I'm overspeaking anything right here, my notes reflect that he was wondering if we should add a rule that a judge cannot reject a filing simply because it's a form. And if there is a substantive reason to reject a form, the judge must state the reason in his order. And that last part goes a lot farther than what the mental health subcommittee is recommending to us today. But I just would throw it out there because forms obviously come up in a lot of different ways. So I just want to make sure that the advice that we're giving the court, whether it's from a mental health perspective or from access to justice perspective.
Thank you, Harvey, and then Andy.
So I have a question for Judge Peoples, and it's what happens if somebody goes on the internet and they want to get a relative admitted, and so they go on the internet and they look for a form, and they don't find the state bar form. They find some form put out, Tennessee, but it substantively has everything required. If you say they can only do it by this form, or we can deny relief just because they use the wrong form, even though it has everything Texas wants. I wouldn't think we'd want to do that. I would think like what Lisa was suggesting, or a preference for this form, or something along those lines. I'm just afraid a pro se may not find the right form.
Harvey, I think
you may not want to spend the time to go find the right form if they're in court. You don't want to say, "Oh, go do it. Here's the new form." This may be an emergency.
Andy.
I think the judge would always have the discretion to go ahead and grant that if the evidence is there and the circumstances justify that. I don't know how somebody could stop the judge from doing that. My concern was more with not letting local judges decide in advance. I'm going to opt out and go my own way. The law is letting me do that, and I'm going to make people do it my way in every county that where it comes from. That's more my concern.
Thank you, Andy.
So I don't necessarily have anything really substantive to add. And by the way, this is my first meeting, so please make fun of me afterwards. But we had a very close family member with schizoaffective disorder and danced around this issue several times. And luckily, the brother-in-law, they have an attorney on the phone, and then me, that they can help with the process. But the powerlessness of this situation family members were put in would only be exacerbated by someone telling them that the form that they submitted was not the right form. And then we're down the road on leaving. So I would probably come down on the side of we need to make it about substantive defect as opposed to forms, because of the overwhelming powerlessness that the family members are, the incredible intensity of the crisis. And they don't just happen once, they happen. And so I just really think from my own experience, making it a substantive defect requirement or whatever was just said about, I'm court rules chair. I'm going to take that thing about what Busby said and talk about that because I think that's important. but it has to be a substantive defect. Otherwise, pouring gasoline.
Great, John and Rich.
Being the clerk of the court that does, I think forms is absolutely, standardized forms are absolutely necessary. Otherwise, you're gonna have, you're gonna have a lot of judges do a lot of different things, and we haven't accomplished what we want to accomplish is to get our hands on mental illness and addressing mental illness one single way. As it relates to some of the comments I've heard, for me, and I know a lot of my colleagues, we kind of get together, as it relates to forms, we generally put forms on our website to make those accessible to the individual. If it requires that the form says this for the state of Texas, then that's, you know, that's kind of an easy fix. But also, as it relates to the judge, judges wanting to do things the wrong way. We're talking about mental illness and everybody have a different view. Will that also now require that judges have some study in psychiatric health?
Rich.
So what I understood Judge People's concern to be is a judge who doesn't want to accept these forms versus concerns about somebody finding a different form. We write the rule to say that a judge can't reject these forms because they have a preference for something else without saying that the applicant is required to use these forms. I think there's a distinction there. If they find a different form that has what is required by the rule, then let them use it. But to say to a judge, you cannot turn somebody down just because they use this form versus something you prefer.
Justice Christopher and then Robert.
I'm in favor of more mandatory language along the lines of that, you know, you have to accept this form. My concern about the proposed language that Judge Peoples said was that we might get like supplements to the form that doesn't have to go through the presiding judge. And that would kind of be an end run around the idea of a form. So I think we need to be careful with that.
Robert.
Rich, my response to you is that forms define the process. What I don't think advocate is the ability to have different processes, different counties, so different requirements, so that a judge in one location will require different findings, different facts, constrain the rights of the individual in a different way. And so having a consistent form is critical. If there was a situation in a local county, a rural county, they aren't able to provide the same process at the right time, possible, I think you might have additional amended or bypass procedure, but those would need to be understood and evaluated, I think, by the administrative judge to ensure that they are appropriate, not just meeting the local judge's issue. And so that's why I think that not allowing deviation without getting into the substantive issue, because the substantive issues, if you don't fill out the form exactly right, but you have information that's necessary somewhere in the materials, that should not leave. But forms that tell the process, the rights of the individual, all of those factors, and I think these forms do a very good job with it, I think should be consistently applied in Texas.
I totally agree with that. My only comment was we need to direct it maybe to the judge saying you have to accept these forms rather than a judge that says, I don't like this form, I've got a different thing, I'm going to make you go back and do it again. So,
but I'm just concerned about a judge who would say, submit these forms, but I'm still going to follow my process. I don't care what the forms say. I'm going to do it my way. That I think is a problem.
Totally.
Marcy.
I agree with what Rich is saying. As flexible as possible. These are pressure situations and they're very difficult. And to tell somebody you filled out the wrong, if they have the information, I don't think that should be prejudice the judge. That said, and I know this is apologize in advance, but it's super important that these forms be extremely. That doesn't mean scanning it and putting it on a website that is unusable where somebody can fill it in on where they don't have or they don't have access. To be available in a way that can be used. I run into this all the time where if something's not searchable, it's not scannable, it's, you know, it really needs to be a potentially fillable form that somebody can fill out on their computer and hit send without having to have any, you know, any of those logistical concerns because they don't have time.
Judge Misk.
I was trying to research it live while we're here. I thought I recalled that in the 2021 legislature, a bill was passed for example, family violence protective orders requiring the use of the protective order. It looks like that may have been vetoed. I couldn't figure it all out as we sit here right now. But so there is some precedent for requiring the use of the standardized. In practice, we use those forms a lot, and either people practice lawhelp.org and get the fillable one, they do type it, or they come in and get it from Biotin. These would likely function the same way. But I second the view that saying the judge can't reject the standard form, and then the other language I want to respond to, the bracketed, if a form is used, the court should attempt to rule on the relief without regard to non. I think either way, if a form is used or if it's handwritten on notebook paper, the court should attempt to rule on the substance, not reject it based on the formatting of. And then I don't even know what attempt to adds to that sentence. So I would suggest the sentence could say the court should rule on the requested relief without regard to non-substantive in the filing or whether the filing party is represented.
Lisa or Kenneth?
Just a couple. Just a couple comments. One, I think the idea that judges can't use forms other than the statewide approved form seems to be a little with what's on the table now from Texas Supreme Court and miscellaneous docket number 229026, specifically addressing proposed amendments to Texas Rule of Civil Procedure 3A, Rule of Appellate Procedure 1.2, and Rule of Judicial Administration 10. So there's a little bit of tension, I think, between what's being discussed and requiring certain forms and what's been proposed by the Supreme Court of Texas in regard to forms generally. But I just echo the comments that have been made already about the need for some flexibility in this space. I too have family members with mental health conditions, and that would be awful to get rejected, to not get the help you need from somebody because a precise form wasn't used in the process. So I think if there were going to be a requirement for precise form, that you would have to give the judge some discretion not to use that form, perhaps if there's good cause or some other standard of that nature, because the rigidity could be detrimental in many ways.
John, then we're going to take our morning.
All right, just quickly, I'm continuing to advocate for a standard process. Perfect example, some years ago, we had a case, a mental illness case that was actually transferred to Dallas County from another county. It's an elderly parent, had no family where they lived, and so the family was in Dallas County, so they moved it because that individual actually needed to be having a guardian appointed. So when you have, and that's one of the things where I think a standardized form is much better with structured language. As it relates to forms, because my office is completely paperless and I know a lot of them aren't. And so everything we do is OCR searchable. All of our forms are fillable forms online. But so I think it's just a matter of us continuing to put our arms around it so that we can so that everything works for everyone, but still be in a standardized process.
Great. We're going to take our morning break. We'll be back in 15 minutes, which by my watch will be 11:05 Central Time.